Disclosure, you gotta let them know. Clear your throat, take it nice and slow. Give the facts, don't twist the choice. Let the service user use their voice. Options on the table, no hidden traps. Right to say yes or right to collapse. When you give the info, freedom grows. That's the meaning of disclosure. Hey! Disclosure.
Welcome to The Law is My Oyster. My name is Declan Olula, but you can call me Bebop. I am a barrister that Neil has briefed to explain the law surrounding disclosure and why it is so important for social carers or anybody in the caring professions to know, but especially before they work with service users. So let's get into it. What does the duty to disclose really mean, and why does it matter so much? Let's start with consent. In everyday life, consent simply means giving someone permission to do something. An orderly society runs on consent. We need to be okay with what is going on around us. An everyday example. May I please borrow your car? Sure, no problem. That's consent. Simple, right? In law, however, consent is more than just a yes or no. What matters is the process behind that yes. Legal consent, especially in social care, depends on three key ingredients. The service user must have capacity. They must be given full disclosure, the relevant information. And that consent must be voluntary. So, repeat after me. Capacity. Disclosure. Voluntariness. Now, let's break those down. Capacity means the person has the ability to understand what you're asking of them at the time you ask them. Not just the action, but the nature and consequences of that action. So if I'm asking a service user to agree to a medication change, or participation in a therapy plan, or anything involving risk, they need to grasp what it is, recognize why it matters, and understand what might happen because of it. If a person doesn't have the mental ability to take those points in, because of illness, disability, temporary impairment, intoxication, mental health difficulty, or age, valid consent may not exist. Capacity is not about intelligence, education, or vocabulary. It's simply, do they have the ability to understand what's happening right now? It is time-specific. Do you have capacity at the time you are being asked to do something? It is issue-specific. Do you have the mental ability to understand what is being asked of you? The second condition, and the focus of this video, is disclosure. A person cannot consent to something they don't fully understand. This is why the law speaks about informed consent. So the law requires professionals to disclose the nature, purpose, benefits, and risks of whatever is proposed. This includes what the law calls material risks, risks that a reasonable person in the service user's position would want to know. You can think of disclosure as turning on the lights so someone can actually see the decision they are making. If there is too little information, then consent isn't informed. If the information provided is too technical, too rushed, or too subtle, then consent might be misunderstood. Professionals have a responsibility not just to tell, but to explain. The third requirement is that consent must be voluntary. That means free from pressure, manipulation, threats, bribery, and even unintended influence. This is what the law calls duress. You can have personal duress, which is where a person does something to take away your free will. You can also have situational duress, which is where you are in a situation where you don't have many or perhaps no choices at all. The law takes voluntariness incredibly seriously, and here's where things get interesting. When looking at whether somebody decided of their own free will, the law will rely on what's called the subjective test. Did that specific person feel they had freedom to choose? This is different from the usual legal standard, the objective test. What would a reasonable person think? Here, it's personal. Did this individual truly believe they could say no? Now, let's be realistic. Social care professionals will usually know more than their service users about health, risk, and safety. So of course they will recommend what they believe is best. In many situations, professionals would arguably be unethical if they didn't try to guide a service user toward the safer or healthier option. The problem is, when does persuasion turn into compulsion? If you talk to a service user and say, "This is the safest option, but let me explain why," that's persuasion, and usually that's okay. But if you say to the service user, "You need to choose this one, believe me when I say it's much better than that one," that's instruction, because there is no explanation, so it's not good. Saying, "You have no choice," that's straight-up coercion, terrible, it's not consent at all. Consent should never feel like a forced conclusion. A vital, and sometimes forgotten, truth in the care professions is this: if refusal isn't offered as a real option, there is no real choice. Many systems accidentally send the message, "You must pick one of these options." But legally and ethically, refusal must sit on the menu too. Because if the only answers the service user thinks are acceptable are yes, yes, and well, yes, the consent that follows is no longer truly voluntary. Part of the duty to disclose is explaining. What happens if the person says yes? What happens if they say no? And any alternatives in between. If there is no disclosure, then there can be no informed consent. If there are no alternatives, then there is no voluntariness. Pressure isn't always intentional. Sometimes the environment applies it all by itself. This is known as situational duress. Imagine someone living in a residential care center, hospital, or group home. Every day, they are told when to wake up, what to eat, what activities are available, when bedtime is. Over time, many residents begin following instructions automatically, without questioning whether they agree, prefer something else, or want to opt out. Their decision-making muscles weaken. Routine becomes expectation. Expectation becomes obedience. So when a staff member says, "We'd like you to do X," the resident may hear, "You have no choice." Not because anyone said that, but because that's what their lived experience has trained them to assume. Once again, voluntariness fades, and the law recognizes this erosion. Information is power, and education is a key tool for restoring decision-making. Service users should be supported to understand options, weigh consequences, ask questions, challenge suggestions, and take ownership of their lives. But duty to disclose isn't about delivering a speech, it's about equipping a person to choose. Let's say a consent dispute ends up in a courtroom. A judge won't simply take the service user's word. Nor will they automatically believe the care provider. Instead, they examine the words that were spoken, the tone used, the behavior of both parties, the context, and evidence from observers. The key question remains, did the service user demonstrate free will? Or were they boxed into agreement? The law steps into the service user's shoes, looking from their perspective, not society's. So, what is the duty to disclose? It is the responsibility of caregivers, professionals, and institutions to provide clear, honest, and complete information, ensuring that every service user understands what is being proposed, knows the risks and consequences, recognizes alternatives, has the right to refuse, and feels genuinely free to decide. Consent is not just a rubber stamp. It is not just a signature on a form. It is a meaningful choice made by a person who knows they matter. When we honor the duty to disclose, we honor the service user's voice, dignity, and autonomy, and that is the foundation of ethical practice. I'm Bebop, and this has been The Law is My Oyster. I'll be seeing yous.
Yo, step into the room with the clipboard flash. We're talking duty to disclose, social care class, not just yes or no. Gotta break it down slow, cause the law wants to know how your answer starts to grow. Capacity's the key, can you see what's on the page? Can you understand the risks, the benefits, the stage? No secrets in the shadows, decisions in the light. Give the info, give the options, get the language right. No pressure. pressure, no pushing, no sneaky manipulation. We respect autonomy, that's the rule for every nation. Disclosure, you gotta let them know. Clear your throat, take it nice and slow. Give the facts, don't twist the choice. Let the service user use their voice. Options on the table, no hidden traps. Right to say yes or right to collapse. When you give the info, freedom grows. That's the meaning of disclosure. Now check it, institutions got power on lock. Routine runs tight like a tick-tock clock. Wake up now, eat your meal, take a bath, don't ask. Soon yes becomes habit like a mental mask. But courtrooms want truth, what was going on inside? Did you feel free to choose or was your will shoved aside? Judge looks at your words, your tone, your vibe. Not society's position, but the user's tribe. So we educate, motivate, knowledge opens doors. Cause a choice ain't a choice if you don't know there's more.